Good afternoon, Counselor.
Good afternoon, Your Honors. May it please the Court, Brennan Wingirter on behalf of the appellant, Mr. Jordan Mosby. May I reserve 3 minutes for rebuttal, please?
Certainly.
Thank you, Your Honor. Your Honors, this case is actually a consolidated case on a probation revocation hearing and a Rule 35 motion hearing. Today we are asking this court to reverse the trial court's orders for 2 reasons. Number 1, the trial court fundamentally misunderstood the new law in TCA 4035-311E2, which gave it the authority to grant Mr. Mosby credit for the time he had successfully served on probation prior to his violation. And number 2, the trial court fundamentally misunderstood the jurisdictional component of Rule of Criminal Procedure 35, which would have allowed it to modify Mr. Mosby's sentence to probation with rehabilitative treatment even after he had been physically transported to TDOC custody. I'd like to be clear at the outset that what we're talking about are errors of law. Our arguments are not grounded in the facts, nor are they grounded in the trial court's exercise of any discretion. I think the record bears out that the trial court applied or misapplied the relevant legal standards in this case. So that's why our brief presented both the de novo standard and the abuse of discretion standard, because under either one, the trial court's orders should be reversed because of the trial court's either misunderstanding or misapplication of the law on both points. As to the first point on the street time issue, the TCA 4035-311E2, that issue relates to a change in the law that was effective July 1, 2021. And I need to apologize for a mistake in my brief. I wrote that it was effective July 1, 2022, which would have been just about a week before Mr. Mosby's hearing. But that law was effective July 1, 2021, a full year before Mr. Mosby's initial revocation hearing. What that law did was change the trial court's ability to grant what we colloquially refer to as street time credit. As former trial judges, I know your honors are familiar with how it used to be. If a defendant got, let's say, a 5-year sentence and was put on probation, if he successfully served for, let's say, 4 years and then violated, and he's before the court on a revocation, and the court determines to revoke and order him to serve, the court at that time, prior to 2021, could not give that defendant credit for those 4 years he had been out on probation. If he's revoked to serve, he's serving 5 years in prison at that point. In 2021, 4035-311E2 was added to fix that injustice. Trial courts now have the ability to exercise their discretion to award some or all of the time that someone is successful on probation before they violate. In Mr. Mosby's case, that's particularly important because he was originally serving a 10-year sentence. He was successfully on probation for 5 of those 10 years before, at least before his last successful home visit, if that is the point where we see that there is anything in the record to indicate anything in violation of his probation from October of 2013 to October of 2018. At his initial revocation hearing, the trial court, I think it is fair to say, clearly was not aware that the law had changed a year before. To be fair, Mr. Mosby's trial counsel did not initially bring that up, but towards the end of the hearing, on the record, there's another attorney who sort of interjects to explain to the court that he just wanted to make sure everyone was aware that the law had changed. That attorney had listened to the proof at the revocation hearing and heard that Mr. Mosby had been successful for about 5 of his 10 years, and wanted to make sure that the trial court was aware it could give credit for that time. The trial court, instead of considering it at that point, said something to the effect of, well, I'll consider that if he files or applies for that credit in an appropriate motion. So I think first there's 2 errors there. Number 1, the trial court not applying the newly enacted Section 311E2. And then 2, once that new law was brought to the trial court's attention, requiring Mr. Mosby to make some sort of separate application is just not required by the statute. whether a person gets some, all, or none of their street time is just part of that consequence determination in probation revocations, that second step of the Dagnan analysis. And so, however, the trial court told him to file something to get those credits, and he did. So Mr. Mosby's probation was revoked. He's sent off to start serving a 10-year sentence in TDOC, and then he files a pro se Rule 35 motion to modify his sentence. In that motion, he asked for the trial court to do two things. Number one, give him those 5 years of street time credit, and number two, to modify his sentence to allow him to go to treatment. His trial counsel eventually joined in that motion, and there was a hearing on the Rule 35 motion. At the Rule 35 hearing, the trial court, in addressing the street time issue first, said, I understand the new law now. I recognize I have discretion to do this, but I'm not going to do it because you absconded. Our position is, Your Honor, that's yet another error of law, because at that point, the trial court's only basis for not awarding any street time, not even a portion of that 5 years, is based solely on the violation. We've not disputed that Mr. Mosby absconded. After 5 years successfully on probation, he admitted he went to Georgia and Florida during COVID to quarantine with his daughter. He was eventually arrested in Florida, but the trial court was clear. I'm not looking at any of that. I'm not giving you street time just because you absconded. Again, our position is that's the violation itself. And when we're talking about Mr. Mosby now effectively doing 15 years, not 10, but effectively 15 years on some form of supervision, 5 on probation, and now 10 in TDOC, if the trial court is going to not award any amount of that street time, it has to put something on the record as to why such an overly punitive sentence on the revocation was warranted. And here, just referring back to the uncontested violation is not enough. It's not enough under Dagnan, and it's not enough under the probation statutes. And if the court has no questions on the 311E2 part, I can move to the second error, which is related to the rehab and the treatment. On that second point, we are exclusively under Rule 35 on that one. So the first one is under the statute, Dagnan, probation principles, and Rule 35. The second one is really just under Rule 35's analysis. And again, I don't want to be perceived as somehow misconstruing what the trial court said, but I do think it is clear from this record that the trial court believed, based largely on the prosecutor's argument at the hearing, that it did not have jurisdiction to modify Mr. Mosby's prison sentence under the Rule 35 motion, because there is a specific reference to Mr. Mosby being in TDOC custody at that time. However, as the court knows, Rule 35 is exactly what saves the trial court's jurisdiction in these circumstances. The rule and the case law interpreting the rule are clear that Rule 35's applicability, as long as it's filed within 120 days of the sentence being imposed, it doesn't matter physically where the defendant is by that time.
So what was the defendant asking to do?
Mr. Mosby was asking the trial court to modify his sentence to allow him to go to rehab. And there's some dispute between our reading of the record and the state's brief as to whether that was a furlough. If that's what the court would like me to address, I'm happy to. So I don't think that anyone used the term furlough other than the prosecutor at that hearing.
Well, whether you use the term or not, wasn't that what's basically being asked to do is a furlough?
So
he was in TDOC custody.
Correct.
And he was asking for temporarily to be moved out of that custody into this rehab program.
I think that's where we disagree, that it was the temporarily part. If someone is in prison or jail and is sent to rehab and then is to return to that jail, technically that would be a furlough, correct? Mm-hmm. Here, however, Mr. Mosby was essentially asking the trial court, please reconsider what we asked for at the revocation hearing. We asked for, don't send me to prison, put me back on probation and send me to treatment. That's essentially what the same thing he was asking for in the Rule 35 motion and at the Rule 35 hearing. The reference to the 6 to 12 months is simply a reference to the particular program he had been accepted to at that time. Safe Harbor at that time had a bed for him, and it was a 6 to 12 month program. But Mr. Mosby was not asking, hey, let me do 6 to 12 months there and then come back to prison. It was, trial court, please reconsider what we asked for, which is the purpose of Rule 35, right? Trial court, we asked you for this the first time, here we are again, and the case law is clear, essentially begging for mercy. We know what that is under Rule 35, essentially begging for that mercy. You didn't give me, you're not giving me my street time. Will you please send me to get some treatment, put me back on probation? In my view, that is perfect. That is exactly what he's asking for. I'm not going to say it's a model of perfect clarity in the way that the motion was phrased, but I don't think it's fair to characterize it as a request to go do a little bit of treatment and go back to prison. It was a request, trial court, please reconsider what we asked for at the revocation hearing at this time. I think the trial court's ruling is very clear. I can't do that because you're in TDOC custody. And it's true, I think if this was a furlough request, I think maybe the analysis is different. As the state points out, could the trial judge have initially granted a furlough the first time? Can he grant a furlough from TDOC? I think those are great questions. They just don't matter in this case, because all that Mr. Mosby is asking for is put me back on probation, let me go do some treatment. I did 5 years just fine before. I can do the rest of my time without any violations at this point. All of that was appropriate under Rule 35, and the trial court certainly had jurisdiction to consider it. The problem we have here, again, why I'm characterizing these as purely questions of law, is the trial court just did not consider that option at all. It said, I can't. You're in TDOC custody. And respectfully to the trial court, that's just not how Rule 35 works. The trial court absolutely had jurisdiction to modify the sentence to one of probation with court-ordered treatment. And then once he completed treatment, he would continue on probation. If he failed out of treatment, he would be revoked and sent back to prison. And that is not anything unusual. It's just that it was asked for at the Rule 35 motion, again, in addition to being asked for at the initial revocation hearing. Unless the court has any other questions, we would ask that you reverse the trial court's order, and suppose it makes sense to speak briefly to the remedy since I have a little bit of time. If the court finds that the record is sufficient to do a de novo review, we are asking for all of the 5 years of essentially jail credit that Mr. Mosby was successfully on probation from October of 2013 to October of 2018. In the alternative, we are requesting a modification to probation with treatment, though I recognize that may be a difficult remedy for this court because that requires us finding a bed and the timing and all of that. So I do think that's probably something that was better suited for the trial court, which I acknowledge. And then finally, in Mr. Mosby's specific case with these whole 5 years, if there's not all of that time partial, and then of course this court could also remand to the trial court, and we could be back there again with instructions for the trial court to actually consider both the 311E2 street time, put its reasoning on the record, go through the second step of the Dagnan analysis, and then two, to actually consider the Rule 35 request without any jurisdictional problems because of the location in TDOC. We would ask the court to reverse, and I'll reserve the remainder of my time for rebuttal if I may. Thank you.
All right. Thank you, Counselor. Good afternoon, General.
Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the judgments because the trial court properly exercised its discretion in determining that the appropriate consequence for the defendant's probation violation was full revocation, in determining that the defendant was not entitled to and did not deserve any street credit time, and because the defendant's a furlough is not a sentence that the judge could have originally imposed at this revocation hearing. To provide a little bit of procedural background, both for Your Honors and for the visitors, the defendant pleaded guilty in 2013 to attempted second-degree murder and was given a 10-year sentence of probation. Sometime in 2019, we don't have the actual violation, but the trial court said it was 2019, his supervisor filed a probation violation warrant, and they had a hearing about that in 2022. The supervisor testified that the defendant had violated the conditions of his probation by absconding, by failing to follow lawful instructions, and by failing to pay restitution or court fees. More specifically, the supervisors testified that the last successful home visit took place in October of 2018, that the defendant had tested positive for drugs in April of 2019, and he had failed to appear for any appointments after that. The trial court went through, after hearing all the proof, and made two distinct findings. First, it found, quote, by a preponderance of the evidence that the defendant is in violation of the terms of his probation. The court then noted that the defendant didn't explain why he had absconded for 3 full years. It determined that, quote, after considering the appropriate resolutions and sentences in other cases, the, quote, appropriate resolution, end quote, in this case, was termination of probation and service of the sentence in confinement. And the court, again, emphasized that it had conducted a 2-part analysis of this and that it addressed its reasons for finding him in violation and reasons for justifying the revocation. As the defendant pointed out, at that time, it seems a third party, another attorney, had mentioned, hey, judge, did you consider the street credit time? And the judge just did not consider it at that time. Said, if the defendant files a motion, I will consider it. But that's exactly what happened. The defendant filed the motion, and the court explicitly considered his request to receive the street credit. I did want to clear up part of the record. In the defendant's pro se Rule 35 motion, he makes no mention at all of this street credit. Rather, that was specifically for this rehab treatment program. And instead, once counsel sort of latched onto that, they filed a subsequent Rule 35, and that's where he asked for the street credit to be held. But the court has a hearing about this, and the defendant testifies a little bit about what his treatment program is, and there's no real testimony about street credit or anything. But at that hearing, the state explicitly referred to it as a request for furlough, and the defendant didn't clarify or correct him, never said, put me back on probation after this. Once the proof was heard, the trial court again made several findings. First, with regards to this treatment program, it determined that the defendant's actions, which included absconding to different states for upwards of 3 years and committing several crimes in those other states, were, quote, reason not to grant the motion for street credit. So the court pretty clearly puts its reasons on there. And then admittedly, the court, I think mine and the defendant's reading of the court's findings with regards to this treatment program are that the court seemed to think it didn't have jurisdiction because the defendant was in TDOC custody. So on appeal, the defendant has argued that the court abused its discretion in ordering full revocation and in denying street credit, and then that he should be entitled to this furlough or rehabilitation. Unless the court has questions on full revocation, I will submit that to this court on briefs. I think we've both adequately briefed that. To turn to the first issue that was brought up today with regards to these street credits, this is a factual question, Your Honors, and the question is, did the court place its reasons on the record? It very much did. Again, explicitly said that these were reason not to grant the motion where the defendant requested Rule 35 in his Rule 35 motion for the street credit. State submits that that's a valid basis. The defendant complains that the court relied on the violation itself. And I want to be clear, the court didn't just say, well, because you have violated the conditions of your probation, I'm not going to give you street credit. The court focused on what that violation was and how egregious it was. Again, the defendant didn't abscond for a month or 2 months. He absconded for 3 years. And while he was absconding, he committed new offenses. And the trial court is expressly allowed to consider the egregiousness of the violation when determining the appropriate consequence, which the state submits also includes when determining whether to give street credit. And that is explicitly in State v. Dagnan, that's footnote 5. So we submit that that was a valid basis for the court to rely on, and that it did so, and it placed its reasons on the record. Unless this court has questions about that, I'll move to this second issue with regards to this rehabilitative treatment program.
Let me ask you about the street time issue, if I could. You say that was brought up as a subsequent amendment to the Rule 35 motion?
It was like a second Rule 35 motion. It was still timely filed within the 120 days, but counsel filed we have the pro se motion, Rule 35 motion, and after that, trial counsel filed a separate Rule 35 motion asking for the defendant to be awarded the street credit.
But the trial court addressed that aspect of the motion on the merits, even though it might have misapprehended the effect of the defendant being in correction custody?
I think those are two separate issues. The court misapprehended whether its jurisdiction, it had jurisdiction to grant a furlough, I think, or what it perceived as a furlough to this rehabilitation program because the defendant was in TDOC custody. With regards to the street credit, the court very clearly addresses it on the merits at this Rule 35 hearing. And again, states what its reasons are, and it's the egregiousness of the violation. So we would submit that it properly exercised its discretion in determining that because the defendant so egregiously violated his probation, he was not entitled to any of that street credit. Moving on, again, I think the state and the defendant simply disagree as to what was being requested. And I have the defendant's pro se motion here, and he asks, he labels it as a motion for sentence modification, says that he wishes to be allowed into a rehab program. This is where it gets a little confusing because it's to complete remainder of the balance sentence to serve. So he seemingly says he wants to serve the whole 10 years in this rehabilitation program, but then he goes on to clarify that it is a 6 to 12 month term at a back to work facility, which he says will help drastically influence his successful completion. And then again, he comments that the Tennessee rules and regulations allow for the chance to enter a rehab facility at least once. I think that's sort of what the state at least latched onto when it described this as a furlough to the trial court. And then I think, again, when the defendant was testifying about this at the Rule 35 hearing, he doesn't say, oh, I want to go back on probation, or, once I get done, you should let me out. He really just talks about what this rehabilitation program is. It's at this location. It's for this long. Here's what we do. I need to go to it because I, quote, have a problem with marijuana. And that's really all he testifies to. And again, he never explicitly says, put me back on probation. He never says the state got it wrong when it called it a furlough. And so to the extent that there's any confusion here, that was on the defendant to clarify. And the state submits that he was essentially asking for a furlough. And because of that, a furlough is not something the trial court can impose at an initial revocation proceeding. So it didn't have the authority to do that. Rule 35 only allows the court to modify the sentence to one it could have originally imposed. Because it couldn't have imposed a furlough, it properly denied it, even if it based it on the wrong reasons. Unless this court has further questions, again, we ask this court to,
All right.
we ask this court to do it. Thank you.
Thank you, General. Rebuttal?
Thank you, Your Honor. If I may, I'd like to just point the court back to the record in a few areas regarding the disagreement between our position and the state's position. First, with regard to the trial court's ruling on the street time issue. In the record, volume 4, page 30 to 31, the court says, the proof before the court is the defendant left the state of Tennessee, went to Georgia, went to Florida, and from 2018 failed to report his whereabouts or failed to report to probation. The court considers that in its discretion as reason not to grant your motion. There's nothing in there about the egregiousness of that violation. If the trial court had said that, again, maybe we have a different argument. But the trial court is simply saying, I'm not granting your motion because I find that you absconded. That's nothing more than the violation itself. And then second, the court does not say that it relied on the subsequent arrest or conduct in Georgia or Florida. The court says the court does not consider. The court believes it could consider, but is not considering the subsequent arrest and convictions in making its decision. It goes on to reiterate, the court specifically is ruling that the fact that the defendant failed to report after October 9th, 2018, admitted he moved to Georgia, admitted he moved to Florida, never reported, was an absconder. The court respectfully denies your motion as to credit for time served on probation. Again, that is very clearly the trial court saying, I am relying only on the fact that you absconded in finding that you should not get any credit for the time you served on probation. Again, volume 4, pages 30 to 31. In addition, Your Honors, the trial court and the state both still have not addressed those 5 years successful on probation, where Mr. Mosby was successful on probation before he absconded. We acknowledge he absconded. That is not the issue before the court. The issue before the court is what is the appropriate consequence for that violation, and does the appropriate consequence include such an overly punitive 0 credit for 5 years that he was successful before he violated? That is the question here. Next, in terms of, I want to briefly touch on the standard. Whether the trial court put sufficient findings on the record is a legal question. That's not a factual question. Are there sufficient findings by the trial court to support its decision under Dagnan? That's a legal question, and the answer to that, frankly, is no. The trial court simply did not do enough at either the initial revocation hearing or at the subsequent Rule 35 hearing, where it got a second chance to go through the analysis. It still did not do so. It still relied solely on the absconding. One factual matter that I will point out, though, Your Honors, is the state's assertion that, and the trial court said, there's no reason why you left. That is in the record. Mr. Mosby explained to the trial court why he was in Georgia, why he was in Florida. It is very clearly in there about his quarantining because of where his daughter lived. That is in the record. We addressed that in our reply brief, that to the extent the trial court found that Mr. Mosby had not explained his reasons, that's an erroneous assessment of the proof. And again, and that is in the record for the court's review as well. And unless there are any follow-up questions, I would like to, again, reiterate that the trial court's conclusion here on both prongs, whether it's the street time issue and misapplying the statute and not exercising its discretion, not putting reasons on the record, or it's the Rule 35 jurisdictional issue, those are questions of law, and we're asking this court to reverse and remand with instructions for the trial court on how to consider both of those, that it needs to consider both of those, and then it must put sufficient findings on the record if it is going to impose such a harsh consequence for Mr. Mosby's first probation violation. Granted, it was absconding. Again, we acknowledge that. That's not the point. And I apologize, Your Honors, because just saying that reminded me of one last point on that. Mr. Mosby, again, the furlough request, I addressed this in my reply brief, so I hate to make too much of it, but that was a pro se motion. It was later joined in by counsel. It was addressed on the merits at the hearing. And respectfully, to hold a pro se motion to a standard of perfection on what words he used would be inappropriate in our mind, and we would ask the court to reverse and remand. Thank you, Your Honors.
All right, thank you. The briefs were very good in this case, and good arguments. We'll take it under advisement.